is not only an important topic but also a very difficult topic to deal with. Mr. Balaji is going to deal with the constitutional provisions. Very rarely we get cases, but still, as a lawyer, we should know the intricacies of this law, the constitutional law, and the philosophy of the Constitution. I invite Mr. Balaji to commence his lecture, and I want to inform you that there is no time restriction for him today. Thank you, Mr. Balaji. Over to you.
Thank you, sir. Thank you so much. Thank you, Mr. Arun, for the introduction. Very beautiful introduction that's been given. Thank you, sir, and thank you for the members and founders of this Tingal Vidaigal for having given me this opportunity to give this lecture. And the topic, I hope that you all are aware of the topic, that it's a parliamentary competency over the National Investigation Agency and other two similarly placed acts, that is PMLA, Prevention of Money Laundering Act, and one another act is Narcotic Drugs Act, Psychotropic Substances Act. So all these three acts, how the Parliament got competency over the act is the prime question, that is, which we are going to discuss today. And before that, I will just put you one case law. The answer to the issue that's been raised in the case law will be the lecture that will be the answer that is going to be given, as that's been given in that case, is the lecture which is going to be given by me today. So this is the case. The case title is Sadhvi Pragna Thakur Chandrapal Singh. The judgment was delivered by Bombay High Court. The small facts, brief facts I will give you about the case, wherein you can put out the issues. The brief facts is that there is a bomb blast in a place called Maligan in Maharashtra. Some people were prosecuted. The offences were registered under the Indian Penal Code, Explosive Substances Act, as well as the Maharashtra Control of Organized Crimes Act, MCOC, that's popularly called as MCOC in Maharashtra. These were the three acts which primarily it was involved, and the case was registered under that. And one of this lady, this is Sadhvi Pragna Thakur, it's a case, the same issue, some other issue, the case pertaining to some other issue was dealt by sir in K.N. Nehru's case, that's pertaining to illegal confinement. And the confinement...
One second, Balaji.
Yes, sir.
Balaji, why can't you wear your that mic near your mouth and the wire?
Sometimes it will not be comfortable for me, sir, so that's why.
No.
Anyway, I'll try it, sir. Anyway, try. Which one is a better one, which I will see that, sir. If this voice is clear now, if it is clear, it's nice. It's good. And this accused were prosecuted under these three provisions of law, and they were also discharged. This happened in the year, please bear with me, please listen to these three important dates. This happened in September 2008. And it says subsequent to September 2008, in November 2008, there was an incident which happened in the Taj Hotel in Bombay. In the Taj Hotel in Bombay, some terrorists came and ransacked the whole building, and some other three blasts were also occurred in the nearby railway station. This happened in November 26th to 29th of November in 2008. Therefore, the central government thought it fit, instead of deputing the CBI, which is a usual police force, for the purpose of investigating, better we can create a new police force exclusively for the purpose of dealing with the cross-border terrorism and any act and any explosion which will have an international ramification, which is having a national ramification, which also will tend to spoil the relationship between the India and foreign nations, or any other offences pertaining to the act which were enacted for the purpose of implementing on or for the purpose of giving effect to for some international treaties, convention, arguments, conferences, etc. So there were some laws that were required for the purpose of what we agreed upon, what India agreed upon in the United Nations or in the any international organization, agency, something like SARC or G5, G7, something like that. So for that purpose, we need to implement the law, and thereby we have to honor the commitment which we have gave to the international community, international agencies, being the civilized, responsible community, India being the civilized, responsible community to the neighboring nation and international nations. So these laws were created, some of the laws were created with these objects. So this is one of the object, NIA is one of the object that was created. So central government deviated from the CBI and created a different police post. It's an agency. It is called as an agency. It is as far as this act is concerned. And this agency was created and it was empowered with all powers of the police station. This police officer who is holding the power under section 3 of the act will hold all the powers as if the officer in charge of the police station will have and enforce within his police station or within his circle. So such a power has been very widely, it's been vested with the officer who has been nominated or who has been declared by the central government. This officer will have his power throughout India, same power that an officer in charge of the police station will have. Now the section 3(1) will say the central government may constitute an agency for the purpose of investigating the offences that were mentioned in the schedule. We'll come to the schedule later. Number 2 of this section, class 2 of the section 3 would be, it was originally some portion were mixing, but that portion had been added in 2019. Second portion, you will simply is invested with the powers exercisable by the officer in charge of the police station. This is the class 2. In the amendment 2019, they said after India some portion has been included wherein they say this power which is going to be enforced, exercised by this officer who has been appointed by the agency or central government, he will enforce the power as per the agreement and treaties internationally that's been committed by India, that's been whatever the commitment that's been given by India, or subject to the local laws of the country in which the offence is dealt with. So this is also 2 important classes that's been added in the subclass 2 of the section 3 of this NIA Act. This is similar to, again, it's almost similar to the CBI. What is the difference between the CBI and this one? CBI said, CBI is concurrence is required. If suppose an offence is committed in the territory of the state, within the territorial jurisdiction of the state, I want to give the investigation to the state, wants to investigate, hand over the investigation to the CBI. In that instant, section 6 of the CBI Act, that Act is Delhi Special Police Establishment Act 1946. This section 6 mandates the state has to give the concurrence and consent to depute the investigation to the central government. Or in case the consent is not given, it is for the constitutional courts under Article 226 or 32, they have to direct that particular offences investigation should be carried out with the CBI and it has to be prosecuted. So these are the 2 mandates that's been given in the CBI to hand over the investigation to the CBI to be conducted. Whereas in NIA, it has been completely dispensed with, and so very wide power has been given to the NIA to take up the investigation. Central government may ask the NIA to take up the investigation, and section 8 mandates that whenever such direction is given to the state by the central government to give all assistance to the NIA for the purpose of effective investigation, it is mandate on the part of the state to give this all sort of assistance to the NIA officers to carry out the investigation. So here the consent is required, here the consent is not at all required. This is one of the major difference between these 2 acts, Delhi Special Police Establishment Act and NIA Act. Sadhvi Pragyan Tagore, being an accused who had already been discharged, she is a lady it seems. The bomb that was blasted in Maligaon was blasted from the scooter. That scooter was registered in her name. Thereby she has become an accused in that case. She was not able to give proper explanation. She said that she has sold it to somebody else, and in fact it was sold to somebody else, but still the name remains in her name. Therefore, the police is not able to accept the explanation that's been given by her, and therefore she has become an accused here. Ultimately, she got discharged in 2008 or 9 or 10. In 2011, this case was transferred to, please understand the three important dates. September, the Maligan incident happened. November, the Taj Hotel incident happened. December, the act was brought into force. 31st of December 2008. The act was brought into force. NIA act was brought into force. Then subsequently in 2011, April 1st, the case was transferred by the central government from Bombay police to Bombay ATS anti-terrorist squad to the NIA. NIA started to investigate. That lady, Mrs. Sadhvi Pragyan Thakur, she wanted to challenge this reinvestigation or transferring of the investigation to the National Investigation Agency. Therefore, she filed a writ petition before the Bombay Court, in which she raised 4 or 5 very important questions. Number 1 is, the first question is, the police is the subject matter of the state list. That is the first question. Therefore, the Parliament will not have the competency, legislative competency, to enact or create, constitute or establish a police by the name of the agency in NIA. This is the first question that's been raised. So, Parliament doesn't have the competency, only the state alone is having the competency to enact. Therefore, this is the first question that's been raised. Second question is, as far as NIA is concerned, no consent is required. The state consent is not required, and therefore, if at all the central government thinks it's a fit case for taking up and giving it to the NIA, and if the case is pertaining to any offence that's been committed, which is pertaining to the sovereignty, security, integrity, territorial integrity, or which is going to spoil the relationship with the other nation, or the offences which is enacted by the law to give effect to the international argument and other commitments of India to the other nations, if this is going to be, the consent is not required. If the consent of the state is not required, then our federal structure is being attacked. So therefore, these are the two grounds that's been raised primarily. The other grounds are, there are no parameters for transfer, which is arbitrary, and other one is that this act came into force in December, but the incident happened in September itself. Therefore, you cannot put the act in retrospective operation, turn the clock back and put it in the retrospective operation, and thereby this act itself has been placed in a retrospective position to cover up all the cases which earlier been discussed. This is what the other ground that's been raised. The one another ground that's been raised is that we have already been discharged. It cannot be reinvestigated without the concurrence of the local police who investigated and closed the case with respect to some other accused. This is one another case. That is not pertaining to the constitutional issue. We will keep it aside. And other 4 things which are pertaining to the competency of the other things which are pertaining to the competency of the Parliament, we will discuss. This is what this thing which happened in the case. So when I discuss with the Constitution, kindly bear the facts of the case in your mind so as to understand the provisions of the Constitution in a better manner. So that's why I given a prehistory about the history about this case. So this is the first thing which I wanted to enlighten to you about the case and the facts of the case, number 1. Number two, now we will go to the Act and see in the object and reasons what are the purpose and reasons for which the Act was enacted. If you could see the preamble of the NIA, that NIA will say the international convention and the commitment that has happened in 1990 and the other convention, subsequent convention that has happened in 1998, both this convention will be there in the preamble itself. That is in the object and reasons, what is the purpose for which the Act is enacted. So I'll take it and I'll go through it just for your understanding. I am just reading that preamble. I am just reading the preamble alone, please. An act to constitute an investigation agency at the national level to investigate and prosecute offences affecting the sovereignty, security, integrity of the nation, security of the state, friendly relation with the foreign state, offences under the act enacted to implement the international treaties and agreements, conventions, resolutions of the United Nations, its agencies and other international organizations, and for the matters connected therewith or incidental thereto. This is a purpose for which mainly, if you can see that this offence had been, this act has been created to deal with an offence, to investigate into the offence which is affecting the sovereignty, security and integrity of the nation as well as the state. If the cross-border terrorism happens and some ramification happens internationally, somebody comes from the neighboring state and ransacks the whole state or some building or some industry or something else, it will certainly affect the relation between the state from where the terrorist came, and also the other implications over the economic implications and other economic relationship and all. Therefore, it will have, and this CBT is a cross-border terrorism, which will have a ramification internationally. That's the prime issue. As far as this object is showing that this is a prime issue for which this act has been created. And any offences that's been created by an act that was enacted for the purpose of implementing the undertaking in the international convention, organization and treaties. So if that act is connected with those offences, so then also it amounts to international ramification. It is also could be termed as a cross-border terrorism, for which the state will not have any subjective matter to enact law at all. The state, as being a federal unit, cannot deal with that internationally. So therefore, the central government took in its hand the competency of how the competency comes. We will discuss later. The commitment of responsibility of enacting the act and doing the investigation, not only within the jurisdiction of India and also beyond the jurisdiction of India also, when the act has been committed within the India. So this is the prime object for which the act has been created. This is as far as NIA is concerned. Now, turning to, and also I'll show you two important sections in this NIA. Section 3.1, it says, notwithstanding anything in the Police Act, that is in 1861. The Police Act was constituted first in 1861. The police, for the purpose, it's a national, that was the time there is no federal, there is no central government, there is no union parliament. It was a unitary in government. That was the time which police was formed only by the central government. It's the only government that was there. And all the members of the service, they will be in uniform. All the members of the service will be termed as a police officers. This happened in 1961. So therefore here, the police, notwithstanding anything stated in the Police Act 1961, the central government may constitute a special agency to be called a National Investigation Agency for investigation and prosecution of the offences under the Act specified in the schedule. This is class 1. If you take the class number 2, the officer shall have all the powers and duties, responsibilities, jurisdictions, privileges, liabilities throughout India in connection with the investigation of the scheduled offences. And I am just shorting out that for the purpose of understanding. The officer will have all the powers throughout India as that of the officer who is exercising his jurisdiction within its police limits, police station limits. So this power is not limited to police station. This limit is throughout the territory of India. The officer has been given a power throughout the territory of India to arrest anybody, to summon anybody, to search any place, to get into any place and to recover anything else. All these powers have been vested under the Section 3 Class 2. Then Section 3 Class 3, the officer shall exercise any of the powers of office in charge of the police station throughout the India. Now it is so clear in Section 3, they will exercise the powers exercisable by the officer in charge of the police station they could exercise, the officer under the NIA could exercise that throughout the territory of India. Which this 2 and 3 should be read together. That's it. So this is what the very wide power that's been given. So therefore it's been named as, it's a police officers. They are all police officers. NIA is a police act. Therefore it will fall under the state competency under the entry number 2 of the list number 2. Entry number 2 of the list number 2 is a state list. List number 2 is a state list. So entry number 2 deals with the police. That police power, subject matter of police power is with the state. Therefore, the argument was taken in the Pragna Thakur Singh's case that the parliament doesn't have the legislative competency. Only the state alone is having the legislative competency. That's what the prime argument that's been taken in that case. So here, Section 4 says, and all the DGP will be appointed, he will exercise the same powers as that of the state DGP. And Section 8, I already said that power to investigate the connected offences is the Section 8. Section 9 is the section which say the state government shall extend all assistance to the National Investigation Agency. So that is Section 8, sorry for it. Last time I said 8. 8 is for the purpose of connecting offences. If any offence is connected, which could be tried by the ordinary court, criminal court. That offence also could be tried if both the offences, the scheduled offences and the normal offences are connected in course of the same transaction and they are inseparably, both are linked together. They are committed in the part of same transaction. So therefore, please read that 8 and 9 also. And apart from that, one another section which I wanted to highlight is 19, trial by the special court to have the precedence. See, any offence that's been committed under this act, any offence that is covered under this NIA, when compared to the other offences in MLA, that is a prevention of money laundering offences, or any other offences which is falling under the narcotic drugs, which is also having connection with which is having international ramification, those offences could be tried by this special court constituted under the NIA. Under the section, this section 19 gives the power for it. The other offences, this act will have a precedence over the other offences. So this is also another thing which you will have to bear it in your mind. So now we will go to the next act, that is next act. Yeah, that's fine. You please do it and we will wait. No issue.